Hello, class. Good afternoon. We are nearing the end of our discussion on the Revised Penal Code. So we are almost there. We are almost finished with Book 1 of the Revised Penal Code. And soon we will begin discussing the definitions, the elements of the crimes as enshrined under Book 2 of the Revised Penal Code. But for today, our topic will focus on the execution of penalties. So what is the scenario here? The scenario here, of course, is that uh, the the case is already finished and there's already a conviction and the judge has already given a penalty for the person who was found guilty for the commission of a crime. So we are now in Article 78, when and how a penalty is to be executed. Okay? So no penalty shall be executed except by virtue of a final judgment. So the penalty that can be imposed to a convicted felon what is the penalty imposed by the judge in a final judgment. So a penalty shall not be executed in any other form than that prescribed by law, nor with any other circumstances or incident than those expressly authorized thereby. So for example, 'di ba, when during our discussions, the penalties may include imprisonment, fine, reparation, indemnification. So if the final judgment does not include with it the payment of a fine, then the convicted felon cannot be made to pay, cannot be forced. Diri hiya pwede periton pagbayad hin fine if it's not included in the judgment given by the judge. Okay? In addition to the provisions of the law, the special regulations prescribed for the government of the institution in which the penalties are to be suffered shall be observed with regard to the character of the work to be performed, the time of its performance, and other incidents connected therewith, the relations of the convicts among themselves and other persons, the relief which they may receive, and their diet. Okay, so of course, our penal facilities, at aton mga presuhan, no, they are managed. They should be properly managed. That's why now the news on the National Bilibid Prison, it's becoming a big issue, a national issue, because at the end of the day, the prisoners, even if they are prisoners, they are also vested with certain rights, no, and privileges, and their dignity must always be enforced as well, no. Number three, the regulation shall make provisions for the separation of the sexes in different institutions. So honestly, actually, female prisoners and male prisoners should be separated. No, they can be in the same building, but diri hira pwede magkahalubilo basta-basta. Okay, so the female prisoners will have their own quarters, the male prisoners will also have their own quarters. So bisan pa tira mag-asawa nga adto sulod ano, they cannot request nga mag-usal at era quarters. No, the male prisoner will be in a different facility, while the female prisoner will also be in a different facility. Kaya ano man, to also secure them para maiwasan gihapon in cases of rape. Kaya imagine those people living in these penal facilities are convicted criminals. No, they have criminal minds. So diri kita maaram itaadera una-una. So to protect them from each other, especially females who are also vulnerable, then they should always be separated. Okay? Article 79, this one. Suspension of the execution and service of the penalties in case of insanity. So if convicted criminal is found to be suffering from insanity, ano matatagbo? When a convict shall become insane or an imbecile after final sentence has been pronounced. So ini, and 'di ba, if he is found as insane or as an imbecile during trial, then it will now become an during the time of the commission of the crime, then it will now become an exempting circumstance. But what if during the commission of the crime he was having a lucid interval, but afterwards, after there was a conviction or a judgment, he is found to be insane or suffering from imbecility? What will happen now? The service of the sentence will be suspended. Okay? Only with regard to the personal penalty, the provisions of the second paragraph of circumstance number 1 of Article 12 being observed in the corresponding cases. If at any time the convict shall recover, okay, and by the way, the convict who shall become insane, no, insane or as an imbecile will be put in a healthcare facility or institution taking care of those persons who are considered to be insane and imbeciles, and also they cannot go out without the court order. So bagalaga perang priso dito, although di represuhan, it era stayhan, they will be put in a psychological facility. Okay? So if at any time the convict shall recover his reason, so maupay na hiya from the insanity, his sentence shall be executed. So that's the time he will be put in the prison. No, unless the penalty shall have prescribed in accordance with the provisions of this code. So later we will discuss what do we mean when we say prescribe, what do we mean when we say prescription. Okay, the respective provisions of this section shall also be observed if the insanity or imbecility occurs while the convict is serving his sentence. So, for example, he was already put in a penal facility. No, he was already in prison, but then during that time, he suffers from insanity or a lucid interval. Insanity or imbecility. He will be removed from prison and will be put in a psychological facility from which he cannot go out without a court order. Okay? 89. How criminal liability is extinguished. So, paano man nawawala? It criminal liability. So, forever liable. For example, if we committed a crime, can we be punished, no? Anytime? I mean, can any person file a complaint? No, anytime. Bisan umabot na 20 years, 40 years, 50 years, uh, can the complainant still prosecute that? So, not necessarily. So, extinguished, it means nawawala na ang liability. So, the person, if the crime is already, or criminal liability is already extinguished, the person will not be made uh, to suffer the penalties. So, di rin niya mapapenalize. Why? Because if number 1, by the death of the convict, so of course, if the convicted prisoner dies or the convicted criminal dies, of course, the criminal liability is extinguished because you no longer have any person to put in a in a prison, 'di ba? So there's no longer a person. Kasi syempre, he already died. Then um the criminal liability is extinguished, but the civil liability is not. What is the civil liability? So, for example, there is reparation and indemnification. If you can still remember, diba? If you damage the property, you have to have it repaired. If it's not possible to repair it, you indemnify, you pay for the value of that property. So, that is a civil liability. But I done, no. So, for example, in here, if the convict dies, it's only the criminal liability and kaprisuhan la ang nawawara. But the civil liabilities are not automatically extinguished. As the personal penalties and as to pecuniary penalties, sama to, di ba? Pecuniary, when we say pecuniary, monetary, money. Liability, therefore, is extinguished only when the death of the offender occurs before final judgment. So, kung before pa na kami ng judgment, so during trial pa, no, during the hearing, namatay ang convict, then both criminal and civil liabilities are extinguished. But, if namatay hiya while serving sentence, nakato niya prisuhan, but may hiya civil liabilities, it's only the imprisonment or the criminal liability that is extinguished. The civil liabilities will continue to be valid. So, pwede lagi hapon manukot. No, and nag-incur in damages. Okay? Number two, or the victim who incurred damages. Number two, by service of the sentence. Of course, if the person has already finished serving his or her sentence, di ba? If reclusion perpetua, like 40 years na maximum or even minimum of 20 years, then they can already be released, no, from the from imprisonment. Number three, by amnesty, which completely extinguishes the penalties of and all its effects. So, for example, rebels, so mga National People's Army, NPA. So that's why those surrenderies, diba, they can be held liable, honestly, for rebellion, diba? If you can still remember, we've already discussed what rebellion is. So those surrenderies, they've already committed the rebellion because they have joined the New People's Army, actually joined them in the revolution. But because the government offers amnesty over them, so if they surrender and they surrender the the machine, the guns, the equipment that they were able to obtain while joining the National People, ano ba yan, NPA, then they can receive amnesty from the government and they will no longer be imprisoned, provided that they surrender voluntarily. If they were captured, of course, they will be held liable for rebellion and all other crimes in relation to rebellion, sedition, di ba? And treason. So if you can still remember our discussion on that. Number four, absolute pardon. So it is the president who can give pardon. So for example, I kept on repeating this. What happened with Gloria Macapagal Arroyo, Joseph Estrada, who else? Robin Padilla. They were given absolute pardon when they were released from imprisonment. Number five, by prescription of time. Later, we will discuss this. What is prescription or prescription of the crime, the prescription of the penalty, and number seven, the marriage of the offended woman as provided in Article 344 of this code. So, mga crimes against chastity, no? So, Article 344, we will discuss that in Book 2. But for the meantime, Article 344 is the crime of, wait lang, the crime of adultery, okay? Adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. So these are actually mostly crimes against chastity. So for example, acts of lasciviousness, but the woman marries the person who committed the acts of lasciviousness, then the criminal liability is extinguished. Also for rape, no, for example, the rape victim marries the rapist, the rapist, then the criminal liability is also extinguished. Okay. So Article 90, this one is prescription of time. So actually, we cannot prosecute crimes indefinitely. There are specific number of years wherein we can only prosecute. Otherwise, the period will expire and we can no longer prosecute. No, we can no longer, if we file a complaint, it will just be dismissed because there's already a material lapse of time. No? So crimes punishable by death, reclusion perpetua, or reclusion temporal shall prescribe in 20 years. So the highest three penalties, diba? If you can still remember, death, reclusion perpetua, or reclusion temporal, it will prescribe in 20 years. So for example, there's a person who committed murder, di ba? Punishable by reclusion perpetua. But the victims did not immediately file a complaint, no? And after 25 years, Sigunta, they finally filed a complaint, no? Can that complaint be accepted by the court? No, because there's already lack of jurisdiction due to prescription of crimes. Nag-prescribe na ang time na pwede ang victim mag-file hin complaint. Now, so reclusion perpetua and reclusion temporal can only be prosecuted within 20 years. Okay? So, crimes punishable by other afflictive penalties shall prescribed in 15 years. So, just take note of the afflictive penalties. Those punishable by correctional penalty shall prescribe in 10 years. Okay? The crimes of libel and other similar offenses will prescribe in 2 years. Okay, so libel. So, if someone uh, nag-spread in rumors against the imo and then they posted it on Facebook, you can actually file false rumors, no? Yunyaknan ka nga, uy, inihikuan kay kuan niya, pukpukin niya. You can actually file a case of libel against that person who spread such rumors, but you can only file within 2 years. If the occurrence already happened 3 years ago, then the action has already prescribed. The offenses of oral defamation, slander by deed shall prescribe in 6 months. Light offenses shall prescribe in 2 months. When the penalty fixed by law is a compound one, the highest penalty shall be made the basis of the application of the rule. So it's always the highest penalty. So if there are several penalties applicable to the crime, the highest penalty, it is the highest penalty which shall be considered for the prescription of crime. So take note, reclusion perpetua, reclusion temporal, will prescribe in 20 years. All those other crimes punishable by afflictive penalties shall prescribe in 15 years. Okay, we can go back to our table. Sige. Our first table on the penalties. So we had this. What are afflictive penalties, 'di ba? So we've already discussed this several times, honestly. So yun nga, 'di ba? Afflictive penalties, reclusion perpetua, reclusion temporal, correctional penalty starts from prisión mayor going to arresto mayor, like penalties, arresto minor. Okay, so arresto minor will prescribe in arresto minor, being the lowest type of penalty, will prescribe yun in 2 months, no, as light offenses. Okay. Computation of prescription of offenses. The period of prescription shall commence to run from the day on which the crime is discovered. So from the day that the crime was discovered by the offended party, the authorities, or their agents, and shall be interrupted by the filing of the complaint or information. So once the victims or the complainant files a complaint or an information in court, the prescriptive period will stall or will stop. No? So, waray na prescriptive period. Okay? Nakag-file naman. And shall commence to run again when such proceeding terminate without the accused being convicted or acquitted or are justifiably stopped for any reason not imputable to him. The term prescription shall not run when the offender is absent from the Philippine archipelago. So, ini nga 20 years, 15 years, 10 years, if nag-escape an offender, gumawa siya Philippines, so nakapatay hiya, tas gumawa siya Pilipinas, then dire ito naran is prescriptive period. Bisan pati 40 anyos nga waray umuli din pag uli niya din pwede gihapon hiya filean hing complaint anytime. Kaya waray man niya din na Philippines, it would have been impossible to get jurisdiction over his person. Article 92, when and how penalties prescribed. So this one, the first one is prescription of crimes, okay? Now let's go to penalties. So this one, the penalty naman, there's already a decision. Now, this is, kanina, for the filing of the complaint ito. So you should file a complaint within the period stipulated by law, such as 15 years, 10 years, 2 years, kung ano't nakabutang nila. But this one naman, this is for the execution of the penalty. So there's already a judgment, there's already a finality, tapos na ang kaso. Okay, may judgment na, may court order na. Pero, and the penalties imposed by final sentence prescribe as follows. So it's the same thing actually. So for example, may ada na may ada na court order ano nga reclusion perpetual and iya penalty. Pero waray ka enforce and penalty kay for whatever reasons waray to kay enforce nga penalty, waray dadak pa for 20 years, no? No. So, 'pag mag-lapse na nga ng 20 years, di rin na hiya pwede prisuhon, no? Kay nag-prescribe naan pag-enforce ang penalty. For other afflictive penalties, it's 15 years. Correctional penalties, 10 years with the exception of arresto mayor which prescribes in 5 years and light penalties in 1 year. So this one, it's in the enforcement na of the penalty. Tapos daan kaso, may din a court order, the convicted person should already be in prison, but for some reason or the other, he was not put to prison for whatever reason man. Then, if maglapse ini nga mga years, for example, he committed murder, and then there's already a court order, no? Pero waray hiya pa. After 20 years, di rin niya pwede dakpon. Okay? Because we cannot indefinitely stay the prescriptive period. So, Article 93, computation of the prescription of penalties. The period of prescription of penalties shall commence to run from the date when the culprit should evade the service of his sentence. So, from the day manggod, nga may ada na sentence, diba? May ada na court order, and it shall be interrupted if defendant should give himself up or be captured, should go to some foreign country with which this government has no extradition treaty, or should commit another crime before the expiration of the period of prescription. No? So, it would, may pag-start with prescription. So, unconvicted criminal, gumawa siya Philippines, dirito, tumakas siya, gumawa siya Philippines. So, waray hiya kadadakop. Pagbalik niya, pwede lagay predakpon, bisan naglapse na 20 years. Kay, must-stop man ang prescriptive period the moment he goes out of the Philippine country, especially if the country he goes to does not have an extradition treaty with the Philippines. Okay? So, there's also a partial extinction of criminal liability. So, by conditional pardon. So, di ba may kita tinatawag na absolute pardon, which also includes pardon of all the other penalties. But the conditional pardon is only limited to the imprisonment. It does not include the civil and all other penalties that comes with the offense. By commutation of the sentence, later we will discuss this, what is commutation of sentence, and for good conduct allowance. So may the allowance, good conduct. Nagbibinutan nga ni it priso, naiibanan ito, it iya penalty pag abot it panahon. So, Article 95, obligation incurred by person granted conditional pardon. Any person who has been granted conditional pardon shall incur the obligation of complying strictly with the conditions imposed therein. Otherwise, with conditional pardon kasi may mga conditions ito ya. There are conditions in the conditional pardon, and if he does not comply, or if he commits another crime while on conditional pardon, he can be put back to prison. Okay? Article 96, effect of commutation sentence. The commutation of the original sentence for another of a different length and nature shall have the legal effect of substituting the latter in the place of the former. Ano ba't commutation? So that is actually related to this one. Good conduct allowance. What is good conduct allowance? No, good conduct allowance, when we talk about good conduct allowance, it refers to the good conduct of a prisoner while in a penal institution. So, if he's already convicted, already serving sentence, but he is a good prisoner, diri hiya nagpipinasaway, no, na support hiya or na follow hiya ang rules and regulations in the institution, iibanan na niya penalty. So, for example, he was imprisoned for reclusion perpetua. Oh, no. Not reclusion perpetua. Let's say, reclusion temporal. Okay? He was imprisoned for reclusion temporal. During the first 2 years niya didto, tas buutan hiya, no? He will be deducted of 5 days for each month of good behavior. So in 2 years, there are 12 months. So 24 months. So kung for those 24 months, waray hiya ginbuhat nga maraot, no, nagbinuotan hiya as a prisoner, tatagaan hiya minus 5 days sa niya penalty times 24 months. How many is that? So 24 times 5 harani 100. Harani 100. Calculate na lang kita. 24 times 5, no? How many days is that? 24 times 5, it's 120 days. So, ano yung penalty for the first 2 years that he has good conduct while in prison, his penalty will be deducted with 120 days. No? So, medyo dakula ay. Almost half a year and may iba na yung penalty. So, during the third and fifth year, okay, sigun tanto reclusion temporal here, di ba? 10 years to 20 years. 10 years plus 1 day, sorry. Do not forget about the 1 day. During the third to fifth year. So, third to fifth year na hiya, while in prison, he is also a good prisoner. He does not perform any illegal acts while he is there. He will be deducted with 8 days for each month of good behavior. So, this is 3 years, and third to fifth year, there are 3 years. So, 36 times 8 days, may ibanan 88 days. So, it's almost 1 year. Naghihapon, iban ito haiya penalty. So, sigun ta 20 years talaga ang penalty haiya. Then, may ibanan na ito. Tikang, pag-abot ha 5th year, may ibanan na hiyahin 408 days. So it's almost 1 year, more than 1 year na actually may iban. So instead nga 20 years and iya serve a sentence, it will now only be 19 years or 18 years. Okay, 408 days na naiban na iya. So during the following years, beyond until the 10th year, so from the 6th year to 10th year, no, buutan lagi hapon hiya, he shall be allowed a deduction of 10 days. Oh, so 'di ba reclusion sigun ta reclusion temporal niya minimum of 10 years, no? So adi na iya 10th year niya. So may diya 5 years this of 6th year to 10th year, 5 years man ito so 60 months times 10 days, that will be 600 years plus 400 600 days plus 408 days and iya pa previous, no? So may ada hiya iban, kay may naman kita 365 days, may ada na hiya iban nga actually more than 2 years. More than 2 years, diba, 365. Basta almost 3 years na ang iban. So kung minimum period of 10 years, haiya, 7 years na lang iya igkukuan, antuson, no? So damo gihapon ito nga mga iban-iban. So this is called the good conduct allowance. So for the first 2 years, it's 5 days for every month, each month of good behavior. Pag third and fifth year, 8 days for each month of good behavior. From the following years until the 10th year, 10 days liwat for each good behavior. Pero kung for example, di ba, reclusion temporal until 20 days. From the 11th month and successive years of his imprisonment, he shall be allowed a deduction of 15 days. So, mas nagtitika ihaprisuhan, mas nagtitika hitaas an allowable deduction haiya penalty. So, that's why some persons are set free, no, earlier than that prescribed by law. Okay? So, I hope that is very clear. Please take a screenshot of this provision. Okay? 98. Special time allowance for loyalty. This one, I want to discuss this thoroughly. A deduction of one-fifth of the period of his sentence shall be granted to any prisoner who, having evaded the service of his sentence under the circumstances mentioned in Article 158 of this code, that is Article 158, gives himself up to the authorities within 48 hours following the issuance of a proclamation announcing the passing away of the calamity or catastrophe referred to in this article. So, for example, if you can still remember the Yolanda time, no? Yolanda, during Yolanda, there were so many news wherein some prisoners were able to go out, 'di ba? Kay naguba man gud ang facility where they were in. So nagkalakat hira kay they were also very worried about their family. So nagpakagawa sila prisuhan. So after the passing of Yolanda, if they surrendered themselves, no kung nag-surrender hira, after nila makapanginano han era family, after 48 hours nag-surrender hera didtohan ha kundiin hirap nakapriso, iiba na nan era penalty in one-fifth, so that's 20%. So if it's reclusion temporal minimum of 10 years, may himo na lang nga 8 years. Imagine automatic 2 years dayon na nag-iiba na iya kay one-fifth, di ba? One-fifth of 10 years is 2 years. So ame to ang mga prisoners nga nagkalagyo during the Yolanda period, they could have been able to avail of this special time allowance for loyalty. Because if nag-surrender hira, waray na nira pa kuri eh. Ang mga jail officers pag pinamili nga hira, of course, that's beneficial to the government. So, then the government will also give due course or due allowance to the person who surrenders himself after the passing of the catastrophe or the calamity. So Article 99, who grants time allowances. Whenever lawfully justified, the director of prison shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked. Also, take note, no? There are actually so many ways wherein the prisoner himself can reduce his penalty. So, bisan pa itiya reclusion perpetua, kung baga maupay man an iya didto may dahiya tinatawag nga good conduct while he was serving his sentence in the penal facility, then he can be deducted. So take note of those things because those are very important, and I hope that you took screenshots of the provisions that I highlighted today. And for this afternoon, uh, I will be sending the attendance sheet at around 6 p.m. with a specific question for me to know that you actually watched the video. Okay, so I will be sending the attendance sheet at around 5 p.m. So I hope that you will anticipate that. So anyway, amula na yan we're almost finished. By Friday, we will be finished with the revised penal code already. So I will be discussing the indeterminate sentence law and the probation law next week in time, and then we can have a short review before you have your final exams. Okay, so I hope you learned something from our discussion this afternoon. So I hope you also took screenshots, no, with our discussion, and I'll just see you again on Friday. We will be discussing the final provisions of the revised penal code under book 1. We're almost finished. The provisions for book 1 is only until wait lang. It's only until well, anyway, I think it's around 113. We had to skip several provisions kay more on ha death penalty adto hera nga are already repealed because our yun we can only ano our topic is only until Article 113. So we've skipped some provisions on the death penalty because again, the courts in the Philippines cannot impose death penalty. Automatically, the penalty will be reduced to reclusion perpetua. Okay? So anyway, that's it for this afternoon. Anticipate our attendance sheet with a short question, very short question in relation to our discussion this afternoon. So thank you so much class for watching the video presentation. I'll just see you again on Friday. Hopefully we'll be able to finish until Article 13. Actually, 113. Actually, it's already also very short na lang na mga provisions. We've already discussed the most important provisions in Book 1 and we will be discussing the indeterminate sentence law and the probation law, as well as the juvenile justice welfare system law. And then by Friday next week, we will be able to review our discussions so that you will be able to adequately answer the questions for the final exam. So that's it. Sorry. That's it for this afternoon. Thank you so much everyone for listening to my discussion and I'll see you again on Friday. So bye for now. God bless and keep safe. See you soon.